I'm going to call our Community Justice Collaborating Council to order. I think we've done a roll call, so we're good in terms of quorum, so thanks for everybody being here today. Apparently there's some little-known codicil in our bylaws that allows a non-member judge to preside when the judge is gone and the vice chair is gone, and so here I am. So I hope this goes all right for everybody. Let's see, approval of minutes. Did everybody look at the minutes from the last meeting? That's a yes, everybody did. Good job. Did anybody see anything that need correction? Does anybody have objection to approving the minutes as provided, and that would be for the January 16, 2025 meeting? All right, Sheriff's made a motion. Is there a second? Our chairman has made a second. All in favor say aye. Aye. Opposed, same sign, so that's passed. Now is our opportunity for public comment. There's a few folks out there. Anybody want to make a public comment? No? Okay, gone. Opportunity. We'll close public comment period then, and we'll start with the business meeting. And I think we've got, let's see. I'm going to start with just a couple of comments that I think Judge Needham would make if he were here, because we don't have it really on the agenda, sort of a court system update. Carl, you're up here. Oh, yeah. To my right here. So I want to start with just a few things about the court, what's going on with the courts in general today, and of course the big thing is that we're going to move. I think we've got a date now. It's May 19. It should be the first day that we are operating in our new courtrooms, and I'm sure there'll be an opportunity for tours and an open house or something like that. I don't know, Ken, is that in the works? I expect it will be. So everybody can come and see the new chambers, the new jury rooms, the new judicial assistant area, as well as the courtrooms. And we're very much appreciative as judges, all four of us, to the county for their commitment to the courts, and to the as judges, all four of us, to the county for their commitment to the courts and to these improvements. So that's coming up. The one thing that Judge Needham did raise at the last public protection meeting that I want an awareness of here is because of the nature of the space, that is, we intentionally put the courtrooms, the new courtrooms, right under the old courtrooms, because that worked very well for purposes of the jail access and the elevator and all of that. And I think originally the courthouse was essentially designed to do that, so that if we added new courtrooms at a later time on the first floor, that the functionality from the jail would work well with the new courtrooms. Now, one of the biggest impetuses to the new courtrooms, a couple of things. One was to add a courtroom so that when and if we're eligible for adding a new judge, we have a courtroom. That's essentially required. If you don't have a courtroom, they're not going to give you a new judge. So that's one thing we accomplished. The other thing we accomplished with this change, these new courtrooms, is that we allowed for secure access for defendants from the jail, from custody, into courtrooms 1 and 4. So Judges Waterman and myself have not had the benefit of a secure door from the jail secure area to get into our courtrooms. So that means that that necessarily defendants have to come through the hallway, through the public, down the main corridor in the courtroom, and of course it creates opportunity for trouble, both in terms of what the defendant might act out, or there are obviously defendants that a lot of folks might not be happy with, and there could be issues of security for the defendants as well. Our new courtrooms have solved that problem by creating a secure corridor behind the courtrooms in courtroom essentially 2 and 3, the 2 middle courtrooms. There's a secure corridor so that the jail can get access to courtrooms 1 and 4. That necessarily makes the courtrooms smaller because the footprint is the same, but the corridor is necessary. So our current courtrooms have a bench space of about 90 feet. Our new courtrooms have bench space of 75 feet. So just the number of people sitting in the courtroom will be reduced to some degree. I figure 2 foot per person maybe is what you can do if everybody likes everybody else. And then our current courtrooms has an entire perimeter around the benches where people can stand. And there's at least 25 people could stand around the edges if you had to. You will see later today, if you want, at 9:30, you can come down and see my return block. We have 90 cases scheduled for 9:30 in our return block, and the whole courtroom will be full. We'll have people in the jury box, etc. There is no perimeter standing room in the new courtrooms to speak of. There's one area that is open, but it's not accessible from the doorway unless you go through the benches. It's basically a fire exit. So that has limited that. That's the long way of saying that the new courtrooms are wonderful, but smaller. So Judge Needham presented to the Public Protection Committee his ideas and the ideas of the judges for combining existing courtroom 3 and 4 into a larger courtroom over time. And of course, that's up to the county to decide if that's doable, when it might be done, but I just wanted our council here to understand that that's an issue. The idea would be that 2 courtrooms could be combined, and then the orientation of the courtroom would go long ways rather than front to back. That would make for a larger courtroom. It would also potentially create the opportunity to create a secure courtroom for problem defendants. I know there are counties in our area that have these kinds of pods for people that are trouble, and so they can participate in court but not be in court per se in the open area. Barron County has some of these facilities. Basically, it's a secure pod that can see the jury, can see the courtroom, can participate and hear what's going on, but we don't have to have constant surveillance by the deputies in terms of, the issues in the courtroom. So I hate to say it, but these kinds of things are becoming necessary. Even in juvenile proceedings, I've had circumstances in my courtroom where I've had 5 deputies taking someone to the ground to be removed. So it's just the nature of to some degree, the mental health issues and other things that we face that could be an issue. So I just wanted to bring this up. Obviously, if you have trials like the Mew trial with the Apple River case, 35 seats or 40 seats in the courtroom is difficult. We seat 40 jurors in a typical case in the gallery for purposes of jury selection. I think Judge Needham noted that he had 60 seated in his most recent medical malpractice case. The other thing is, too, just in terms of the number of parties, in many of these larger cases, particularly civil cases, we often have multiple parties requiring multiple tables, and of course that becomes an issue as well. So I just wanted to bring that up. And the last thing I'll say about that is, because of the limitations of what the court system will provide to St. Croix County, Old Courtroom 4, Judge Waterman's courtroom, will not be functional after all the changes have happened. We did talk them into allowing us an additional courtroom that would be functional for reserve judges and for our use in general, and that will be courtroom 3 will remain active. Existing courtroom 1 and 2 will be for the commissioners. All 4 of us judges will be downstairs. Courtroom 3 will be available as a spare, so to speak, for visiting judges and our other use. It may turn out in some of these large hearings like we're having today, we might actually use courtroom 3 to accomplish that. But courtroom 4 will not be available for use anymore because we can't take a record there. The sound system won't be functional. So that's that. Any questions about that? No? Okay, well, good. Let's see. Next, we were going to talk about, I'm going to wait for adult treatment court updates because we've got treatment court subcommittee and it's kind of, that's under subcommittee reports. We'll just handle it then. Let's see. TAD grant updates.
Yeah,
there you go.
Thank you, Judge. I can take that, and then if Kate wants to jump in, she can as well. So we just got word yesterday that our Q4 financial report for TAD was approved. So 2024 is closed out, and we're now on to 2025. Carl, I don't know if you want to talk about your new staff in diversion that was part of the 2025 grant.
Sure. We previously shared with JSC.
Push your button.
We previously shared with JSC a part-time position that did data entry for the reporting. We recently got additional funds so that we each, basically JSC has their own part-time position and we have our own part-time position, which is a huge help.
So that's a 2025 update. Otherwise, I don't know that we have anything else. We're just continuing to move forward with TAD. Excuse me, with TAD.
There is one new thing about TAD that's on the horizon that I think is worth noting, and that is the new governor's budget. I'm on the legislative committee of judges, and so we monitor new legislation that could impact the courts. And we just were notified that when the governor submitted his budget, it changed some things about TAD in certain fundamental ways. Now, the governor's budget may or may not be acted on by the legislature in its present form, and the TAD provisions may not be there. But here's what it did. It moved the TAD function to the court system from the Department of Justice. I don't think the Attorney General is too happy about that, but nonetheless, that's what's been proposed. And it moved the actual staff people as well to the court system. It also made some interesting changes, and I'm paraphrasing now, I might not be exactly right, but presently, TAD funding for treatment courts, for example, is competitive. So, and we've been one of the winning competitors for a long time. The governor's idea is it won't be competitive. Essentially, if you've got a treatment court, you'll get money. And there'll be, this all goes to the issue of sort of state support for the circuit courts at a county level and that transfer of funds. And apparently, the idea is there'll be a base level of support, and then if you have a treatment court, you'll get this much. If you don't have a treatment court, you won't get that money. And I don't know, again, obviously, how much money it is, I don't know. But it's a different way of doing TAD that may be on the horizon and just something to be aware of. So, let's see. Well, I guess Justice Support Services updates is next.
Sure. So really what I want to talk about, there we go. Really what I would like to talk about is an exercise that we're going to be doing in June. Bob Rarrett and I and Ellie Clausen from Public Health are spearheading this this sequential intercept model, this mapping exercise that we're going to do with SAMHSA, the Gaines Center. really to kind of identify gaps in our system that exist. And so they'll be coming here on site in June for a day and a half. A lot of you may have received an email to sign up for that mapping exercise. That's what that is, so I can provide some context to that. So I would ask you to have a look at that email that came from me, I think it was last week. And if you can't make that, if there's someone from your staff that you could designate to attend that day and a half, or at the very least, if you could attend part of it one day or the other, or even if it's just a couple of hours, that would be really helpful. Any questions on that? Or Bob, if you would like to jump in, by all means.
No jumping? Okay. All right, let's see. Substance testing updates.
Just very brief, we continue to test in New Richmond, Tuesdays and Fridays, here at the Government Center, Monday, Wednesday, Thursday. It seems to be going well. We've been doing that for a year now. It's kind of hard to believe, but yeah, so we're a year in. I don't have any really updates on that. We continue to test for treatment court, pretrial, diversion, as well as some family cases. That we just continue to move forward with that. We did receive a request from Pierce County's treatment court to consider helping them out with some of their testing. So that's something we're taking under advisement. I had a chance to meet with their treatment court coordinator. They have a very small number of cases, but they're really looking to kind of meet some of the fidelity issues for testing for treatment court. So if we can help our neighbors out, like a little bit of a professional courtesy, at least temporarily, that's something that we might do. But otherwise, no updates on testing unless Shelby or Kate have anything.
Well, once again, how about court navigation? There we go. Shelby.
Thank you. We are starting a court navigator pilot program aimed at identifying gaps and opportunities that a court navigator could do to help support success and efficiency. This isn't a new idea or unique to St. Croix County. This is a role that is gaining popularity right now nationwide. And notably, there are opportunities here to sort of customize or tailor this role to any individual jurisdiction's needs. Right now, we have a very narrow focus on criminal intake court, where this court navigator is available to out-of-custody persons to offer guidance and answer any questions that they can before, during, and after intake court. They're not giving any legal advice. We're hopeful that this has the potential to not only positively impact the defendant, but long-term, it could also maybe lead to a reduced number of court dates, case lengths, and then that could mean great cost savings as well. We started this in Judge Waterman's last intake cycle on the 24th, so we're now halfway through week 3 in Judge Nordstrand's courtroom. We've been working closely with Judge Waterman to debrief and discuss often each day, because each day has been a really big learning experience. In the background, I've been gathering data as far as the number of people served and what sort of things we're doing with them and things like that. But anecdotally, I do want to share a couple of things that I've noticed. Going into this, I didn't expect to have the contact with the families of the people who are actually in custody. I didn't expect that going into this, so a lot of folks that are in custody have loved ones appearing at criminal intake court. They have no experience in the criminal justice system, and they have a lot of questions, and the court navigator has been able to be there to hopefully answer some of them and offer some guidance. One person was simply very nervous in criminal intake court, out of custody again, and just wanted somebody to sit next to. There was a parent of a defendant that was in court. Her son wasn't there. He was actually hospitalized at the time. She expressed that she thought that he needed to go to detox, but she seemed pretty lost with what her next steps were. We were able to offer her a list of detox options and with additional, information like insurances that are accepted at each of those and things like that. I really want to thank each of the case managers within justice support, because those are the people that have been stepping up to fill this role. They are taking turns, dedicating about 2 hours a day to being present in criminal intake court to help with this, in addition to their current duties and their jobs as pretrial and treatment court case managers. So they're taking the time to take on these extra roles, and they're also having a willingness to step into this role that is new and exploratory, and every day's been different. We don't necessarily know what to expect with this, but that was also the point of piloting this. And I also want to thank other departments that have offered feedback and time to meet with us as we learn how a court navigator could best fit within St. Croix County in hopes of minimizing any sort of workflow disruptions. And I also mentioned the narrow focus on criminal intake court currently because of staffing constraints. Like I said, that 2 hours a day that we're taking other staff to fill this role. I'm hopeful that we would have the potential in the future as we move through this to maybe expand this to other areas, or also maybe pivot to things like help with restraining order applications, perhaps assisting defendants that have multiple complex cases or different case types. They're involved in a family case and also a criminal case and things like that. And then also there's the potential for maybe working with behavioral health staff in the jail to support reentry. I think that there's a lot of possibility here, but right now we're being very careful, like I said, to stay very narrowly focused in this and use it as an opportunity to learn.
Well, good, thank you. Judge Waterman, you had a full 2 weeks of this. Any thoughts?
I think Shelby covered most of it. My intake in the past 2 weeks was light on volume, so it's hard to say the full potential of the navigator idea. I would say what I think is particularly valuable, especially at the initial appearances, is that people coming to court don't have lawyers at that point, so they don't have somebody to ask questions. They don't have somebody to guide them, show them where to go, explain what things mean. Intake court is very fast. It happens very quickly. A lot of legal terms are thrown about. A lot of consequences come out of that. And judges don't have the time nor the ability to answer every question that individuals have, whether it be a defendant, a victim, a family member. So I think the navigator fills that role very well. I did not have too many occasions where I made a direct referral to the navigator, although there were a few. But I did see Shelby very active in the back, going in and out of the courtroom, working with people, helping people out, showing them where to go, what to do, things like that. So I see some real potential with it.
Right, and if I could just say, I think that as Judge Waterman says, folks just don't know what to expect or what to do or how to get a lawyer or what form would you use to do that or where do you start? And so if somebody's there to sort of give them that initial bit of advice, it's a big help. And I think it helps our system overall because to the degree that they're more efficient in getting to resources, getting a lawyer, that's going to help reduce the time that we have to deal with these cases in general. I mean, they got a lawyer, we can move faster, we can get to resolution one way or the other in a more expedited way. So I think it's a good pilot. We'll see how it goes. Let's see. Diversion and OER cases. Oh, this is one of my favorites. Come on, Carl.
So a common charge we deal with is operating after revocation. Basically, it's a misdemeanor charge if somebody gets a drunk driving, OWI. They get their license revoked. If they drive again during that and they're caught, it's the OAR, operating after revocation charge. There's a decent quantity of them that go through the court system. And the standard offer is always get licensed, we amend it to a ticket. The problem is it clogs up the court system when they generally it takes people 6 to 9 months to get their license back because a lot of times they have to pay fees, they have to deal with tickets out of other states, or maybe have to get up to date on, sometimes it's involves child support. So the Judge Nordstrand had mentioned that I think it's Chippewa County has a pre-charge diversion program for OARs to try to keep them out of the court, off the court docket. So we're going to implement that. I've discussed it with the chiefs. There's not much of a difference for law enforcement other than when they give somebody a summons for court or a notice to appear, it has to be set out a couple months so that we can draft the paperwork for pre-charge diversion, mail it out to the defendant, and then they can sign it and mail it back to us. And then if they don't, that's where we just charge them. They'd come in on their notice to appear. If they do, they'd have time then to get their license. It's not something we have the capacity to, the staff capacity to actively monitor and check in with them regularly. It'd kind of be on their own to do it. And then I'm thinking right now, we haven't finalized everything, but probably 9 months. At the end of the 9 months, if they haven't got their license, we'll run them. Then they'd get charged and a court date for their initial appearance. I think I'd probably have that set out another 2-3 months so that hopefully that's the last, if they just need a few things to get done, that would be their motivation. Now they know they're charged to try to get it done before their initial appearance. It wouldn't be for people with other criminal charges because it doesn't really accomplish anything then because they're already in the court system. There's a few things we still have to work out, the specifics on who would get it, who wouldn't. We probably wouldn't do it for people who just had an OAR charge recently because they already had the opportunity to have a deferred prosecution agreement and get their license and obviously didn't do it. There's some other things that would change. There'd probably be more traffic tickets that would be for 1 o'clock intake because a lot of times they're stopped for a traffic offense. They get a traffic ticket and then the officer finds out they're also revoked, so then they get a court date. But we're not gonna, so they'd still have to deal with their traffic tickets, which would have a 1 o'clock intake because they'd also get the summons or the notice to appear for the OAR. So there's a lot of details we still have to work out on our end. Guidance to the attorneys on what cases are appropriate for it, what aren't, what ones don't make sense, and then kind of the specifics on, what things like what happens with somebody's bond money if they post, and then we do a pre-charge. What happens if they can't post bond? I think we direct that they be released, but hopefully get the pre-charge signed prior to that. We'll see, but so a little bit of logistics to work out, but it shouldn't be too much of a change really for law enforcement at all. We'll just have to give them the heads up that, effective this date, summons for standalone OAR charges should be set out 2 months. And the rest is mostly things we have to figure out and work with the clerk's office on.
Good job, Mr. District Attorney.
I just have one quick question for clarification, just so I have an understanding. You mentioned, this wouldn't be subject to people with other crimes. That population, though, that has an OAR that is committed while they're on bond, that has the potential for a misdemeanor bail jump because of the bond violation, are those people to be excluded because there is the potential for the crime, or are those people still going to be subject to the diversion as well?
You mean if they have a pending crime and then they get pulled over?
If they're on bond, a pending crime that they had been released on custody on a signature bond, and then they pick up that OAR has the potential also to have a bail jumping associated with it because of the bond violation. Are those people still going to be diverted, or are those people going to be put back into the system?
I don't think we do a diversion on people with pending charges because we're not accomplishing anything of lowering the docket because, generally they just trail the primary case. So it's not like if we gave them a pre-charge, we're not lowering the caseload or the, court time at all because they just trail the pending case.
Well, they still have the initial appearance, so you still have, people coming into custody that's still clogging up the court's calendar.
I think the idea with this from my end is we have a lot of defendants with a standalone OAR charge and probably some traffic offenses, and it's not an efficient use of court time for those cases. But when people have other charges, we're already bringing them back to court anyways.
Do you have an estimated time frame too when you think this is going to be put in play?
Probably I think just for ease with communication with law enforcement, it'd be easiest to start it at the, beginning of a month. So probably April 1st or May 1st.
All right.
Nice. All right. Judge Waterman.
Is there going to be assistance with helping navigate the process to get reinstated? Because frequently, folks just don't know what they need to do. They get stuck with DOT compliance. They don't know where to go to pay their fines. Sometimes they just need a little bit of help to get that process started. So will there be any guidance or assistance?
Well, one of the things we'll have to draft is a letter that goes with the pre-charge diversion, and we can include some basic info on that. But we don't have the capacity to handhold these defendants through the process. We don't currently when they go on DPAs. It's up to them. So no, other than, trying to put some information in the letter. And I'm sure sometimes they'll call and we're not going to just hang up on them, but we're not going to be actively calling them and helping them walk through the process.
Maybe a good letter explanation, because I know they've got to go, sometimes they've got to pay their money and go get the AODA assessment, and then, there's different things they might have to run through in order to get to the point of getting an occupational license or otherwise.
Yeah, the concern I would have is that while self-starters will be able to get that stuff done, a lot of folks are not. And it's just going to be 6 months later, and they're going to be in the same position that they were when they started.
I mean, that's the same thing we have now, too.
Exactly, that's the problem.
And I don't have a solution for that. We simply don't have the bandwidth to hold the hands of all these OAR defendants.
Well, one thing I will say about the Chippewa model is, and I think this is correct, they actually have a staff person that's tasked with facilitating people getting through the system. Now, I'm not advocating, I know you've got staff limitations, but I think it would be worth talking to Chippewa about how do they manage that, how do they achieve success? I mean, I think the judge down there said that they've been doing it for years, they've had a lot of success, and they use a staff person to help people get through this. Because it's not without staff cost to do all these cases. We have to get public defenders appointed, we have to get court-appointed attorneys appointed when they're actual cases. We've got to go through, we've got to get payment plans from the clerk to pay for the court-appointed attorneys, and all this stuff is happening, and somebody's doing all that too. So, and I'm not saying you got to go find your staff to do it, but there's a balance here that could be struck, to Judge Waterman's point. So.
And maybe I do like Judge Waterman's point, and to say, I understand you don't have the maybe capacity to kind of do these individually with each person, but to maybe on that template letter say, hey, here is the link to go to the DMV to check your eligibility for your license. Here is a numbers, if you need a driver safety plan and an alcohol assessment, here are the local numbers to contact to reach out, just to kind of have a template to cover basically 90% of the population of what they need to kind of do next. And maybe also that kind of threatening language too, to say, if you are not going to, do this, you are going to be required to come back to court, face that, to kind of have that threat, because I wonder about if they just kind of know that they have 9 months and it's just going to expire, and it's just, without that kind of threat that you're going to have to come back into court, they may just kind of just forget about it and stuff, and maybe have those deadlines of, hey, an alcohol assessment might take a couple months and you need to kind of factor that in.
Yeah, that's exactly what I was thinking, was having, at least for the common or the most common situations of what things that hold people up, information on what to do in the letter, along with, if you don't get it, the offer is going to be plead to the criminal charge. And then once we file the charge, if they're not revoked or if they're not relicensed, set it out for intake, after they get that criminal complaint for maybe 90 days, and that's their final wake-up call that they got to get on it.
All right, anything else on that? Good discussion. Next topic is Bob. Talk about Kitty Road's facility. Go ahead.
Yes, thank you, Judge. I'm pleased to announce that our Kitty Roads Memorial Memory Care Unit is now open. This is designated as a dementia crisis stabilization unit, so it's meant to be a short-term 28-day length of stay for persons with dementia and some sort of crisis related to that dementia. This facility is located at our healthcare campus. It's a separate facility, but it's physically connected to our nursing home. It's been sitting empty since I've been here, so almost 5 years, during COVID, and then after that, it was workforce-related reasons why we couldn't open it. But last fall, our Deputy Director, Char Lopez, wrote a grant and was awarded a grant for about $600,000 to enhance the facility and offer some financial incentives for employees to incentivize the workforce. We were able to hire enough CNAs mostly to staff the facility and get it all fixed up and ready to go, so that we had a bunch of enhancements to it related to what that population might need when they come.
I think it stopped.
Okay, maybe
There we go.
it was telling me something. So we were able to, with that money, we were able to get the facility all ready to go. We hired people, and as of February 18th, we were able to open it. So it's currently open. We have some availability. We're starting off rather slow in terms of admissions, but we hope to increase to our full capacity of 10 beds in the near future. It's contingent on staffing, so we have to continue hiring and building up our staffing. It's a 24/7 facility, and again, it's intended for a 28-day length of stay for folks to stabilize them, refer them back to where they were before or to a more appropriate facility for longer-term care, and provide care coordination and discharge planning and all of those things that go along with helping someone go back to where they had been or to go to a different level of care. I don't know what I might have missed, but if you have any questions for me.
Questions? Go ahead.
There was a really nice video done by, if I get this right, Western Wisconsin Journal. It was kind of a video tour of the facility, so I'm not sure where that might be available, but I happened to see it on Facebook, and I thought it was really well done. Kind of gives you a little inside scoop as to the facility itself, so if you're interested, it's out there.
Yeah, thank you, Supervisor Long, and that it should be available on the website. I think it might be. If it's not, it probably will be soon. And it was where Char Lopez and Sandy Hackenmiller walked around with the reporter, the interviewer, and walked around the facility and showed it off a little bit. If that's not available, I can find out on the website. I can find out when it might be.
Any other questions? Well, thank you, Bob.
Sure.
Oh. Nope. All right. So subcommittee reports, and I guess the first one is behavioral health. Bob.
Thank you, Judge, to put my glasses on for this. Let's see, our Behavioral Health Subcommittee last met January 27th. We discussed what I just spoke about, the Dementia Crisis Stabilization Unit. We talked about the other grants that we are currently, well, let me start with the sequential intercept model that Phil discussed earlier today, so we had some discussion about that. We talked about policy papers related to legislative priorities for Health and Human Services. And at the time, there was an upcoming WCA legislative conference, some discussion about that. We had a discussion around Chapter 51 and transportation concerns. Primarily, that was around how to transport persons with severe medical or psychiatric conditions when they needed to be taken to placement somewhere, whether that could be an ambulance or it had to be by law enforcement. I think others can help me here, but I believe the statute reads that it has to be a transport by law enforcement currently. Is that right? Yeah. So discussion around what might need to change within that statute for specific cases where severe psychiatric or medical conditions might make that a difficult transport for law enforcement. We talked about billing related to our crisis services around co-responders, mental health co-responders in particular. And just one second. That was the bulk of our discussion. Our next meeting is scheduled for March 24th at the Services Center. But I'll see if you have any questions about any of that.
Any questions? All right, let's see. Next is treatment court. Maybe I'll let Kate start with, what would you like to tell us about treatment court for the subcommittee? And then I'll talk a bit too.
Perfect. I think just one of the big things that we are working on currently is collaborating with all of the treatment facilities that we have in St. Croix County. So yesterday we had a subcommittee meeting, and all except for one treatment provider in our county was in attendance. It was great to see how we can collaborate, who does what their specialties are. And so obviously for our treatment court, we can use each of those, but for our county. So it was great that behavioral health can do this specifically, and Hazelden can do this for us, and so on and so on. So we are going to start to have more of those meetings. So if anybody would like to join, that would be fantastic. That's probably one of the big things that we're working on right now.
All right, and I thought, we had our treatment court subcommittee meeting yesterday. Our next one is in July, I guess, July 2nd. It was a very good meeting in the sense that we had all these providers, and, you know, we hear about these treatment providers. We know we need services. We had Programs for Change, which is the provider for our treatment court. They provide us with intensive outpatient treatment. They don't have inpatient treatment availability. We had Health and Human Services represented there as well in terms of the kinds of programming that they can provide. Not intensive outpatient treatment, but they have mental health services, assessment services, and other kinds of treatment services that are available there. We had Berkwood Treatment Center as well. Berkwood is out by Burkhart. They have residential treatment. They're growing. And I want to say something in a moment a little bit about they just opened a sober house, which is kind of a new thing and very helpful. But they were represented there as well. Kinnick Falls Treatment was there as well. They're down in River Falls area, been around a long time. I think Kate has told me before, they largely serve the Minnesota population because we can't seem to figure out how to get them paid with the Wisconsin resources that are available through Badger Care and et cetera. And we had Hazelden. And Hazelden is new to our community and new to Wisconsin. Obviously, they're probably the oldest. They're the oldest 30-day program in America. They started 30-day 12-step type residential treatment at Center City many, many years ago. They're now called Hazelden Betty Ford because of the merger. And I want to invite everybody, if you're interested, to come to an event tonight at 5 o'clock at the Phipps Center. It's called This Is What Recovery Looks Like. And it's a program, I think it's in some ways kind of an introduction to the resources in our community, particularly adding Hazelden to the mix. They're opening a facility down south side of the freeway on, I think, in one of the floors of one of those bank buildings. They're going to have mental health and outpatient treatment services available in Wisconsin in person for the first time. This is their first facility in Wisconsin, which I think is significant, and I think they think is significant. But one of the interesting folks who will be there tonight is William Cope Moyers, and he's a New York Times best-selling author and vice president at Hazelden, I think. He's the son of Bill Moyers, the journalist, and his book, The Broken, was a bestseller at the time. And he'll be there to talk about Hazelden and his experiences, and so that could be very interesting. So that was all very positive. In terms of treatment court, we're down to about 8 participants right now, but we have one approved for awaiting sentencing, so that would move it up, and we have 5 more in various stages of admission. So we're on the upswing, I think. With regard to inpatient treatment, that continues to be a challenge, and we talked about that with the providers yesterday. There is no easy solution. We had them all in the room and said, how do we make this work? How do we get people into Berkwood? Can't do it. Not right now. We're working on it. How do we get people into Connect Falls? Can't do it. Not right now. We're working on it. So it's a matter of figuring out, whether or not they can take Medicaid-type payments. What's the funding level that'll be provided to them for those payments? What do we do about the fact that residential portion of the treatment is not provided by Medicaid in Wisconsin? And what's the gap that can be filled perhaps by the county? But even that's problematic. But there are people, we're working on it, because it's kind of frustrating to have inpatient treatment providers actually in the county that we can't use. And I know why. I just wish we could figure a way forward, and I know there's some smart people working on it. So the other thing I wanted to talk about was the sober living issues. I was glad to hear that Berkwood just opened a sober house facility in Burkhart, right near their facility. I hadn't heard that before. They are also open to not just folks who are coming out of their program, but within limits, because they want to have availability for their program. They would take people from other treatment programs. Perhaps they come out of a 30-day treatment somewhere else, like a lot of our DOC folks go to Farman. That could be a possibility. So that was all very positive. I will say one thing from our discussion. There was certainly some, let's just use the word concern, that's a good word, about the regulatory hurdles to sober houses in our county. And I don't know I don't know the details. I don't know if it's at a county level or a local level, whether it be town, village, or city. But I know they had some difficulties in getting to the point of being able to open. And we have experience that people are not necessarily enamored with the idea of a sober house in their community. But we've got, Onyx House operates a number of them in our county, very successfully and very helpful to our folks in treatment court and other folks. And the reality, at least one judge's view, is the folks who need these kind of services are in our county. They are here. They aren't going anywhere. So we might as well develop an opportunity for them to stay in safe, monitored places to try to work on their recovery. And so if there are regulatory hurdles, we should at least address them, see if there's things that we can do. And I don't know, I asked the county administrator perhaps to talk with community development to see if this is an issue. But in any case, the last thing I'll say about sober housing is we have none for women in this county, 0. It is a very, very big problem. And thankfully, the good news from our meeting yesterday was the representative from Hazelden, who Hazelden operates halfway houses and the like in Minnesota. They also are very well connected to the sober living community in St. Paul, which is very strong. I'm a graduate of sober living in St. Paul myself many years ago. They indicated that there is interest in some of those providers would be willing to come to St. Croix County And they're actually looking for real estate in the county to open a female sober living facility. So that would be very positive. And so that's why, as we look at the opportunity to create a regulatory environment that would allow this to happen, I think that'd be very positive. So I think that was it. Questions about any of this or comments? Go ahead.
Ailey Peterson with Western Wisconsin Health. A comment, the challenges that you described are real. We face them routinely, particularly when it comes to Badger care. For the last 2 years, we've been attempting to navigate those challenges, and we recently had a breakthrough. And we have received approval from DHS to be able to bill Wisconsin Medicaid for outpatient substance use disorder treatment.
Wow.
And so we do plan to launch a new outpatient substance use disorder treatment that includes medication-assisted treatment by a primary care physician, and then substance use disorder behavioral health counseling. We'll launch April 1st, and we'll be able to accept 100 patients into that program. So that's another resource to add to the list in our region.
Will you be doing intensive outpatient treatment?
Correct. Yep.
Wow.
And so that's something that Bob and I have worked on. The county has been supportive of our medication-assisted treatment work over the last 2 years, but the additional enhancement of substance use disorder counseling and then launching an official outpatient services, that's the new aspect of these services. So certainly I'll continue to work with Bob to make sure that there's an awareness of how patients can get into that system. We've been able to kind of fill openings that we have right now just through those individuals who come to us through the emergency department. But we will have additional access points. So another resource for treatment courts and others to be aware of for care in the region.
Well, that's wonderful. Any other thoughts or comments about this? Okay, let's see. Child welfare, juvenile justice. Ms. Patel?
Morning. We had our last meeting back in January. At that time, we had, the county had recently received a family treatment court grant. So at our meeting in January was the first time that it had been presented to the subcommittee. We had brief discussions on what the grant application looked like in terms of what the program proposal had been. We have a small working group that is still kind of working on what it will actually be, but at that point it had just been kind of presented to the subcommittee. We talked about what population we're hoping to serve in that treatment court, and how those families would be able to enter that program. What the differences between adult treatment court and family treatment court would be, still fleshing out all those details, but it did seem like there's a difference in population that we're trying to serve. Also a difference in the outcomes, what our goals are in the two different courts. So we're going to continue having that discussion at our next meeting next week on the 20th, but it is an ongoing thing. St. Croix County, I think, it is $125,000 per year for 3 years guaranteed, and then there's an option. There's two options for additional 1 year's extensions for $125,000. So we also worked on a youth justice intervention pamphlet. So they're informational pamphlets for kids and families that are involved in the truancy system or the delinquency system, juveniles in need of protection system. Those were reviewed by the committee. They have been reviewed by CSIP, and I'm just putting some final touches on them before sending them out to the judges again for final review. And those should be printed and out for distribution sometime in April. We also talked briefly about CASA. So Barron County's CASA program has dissolved. So they are no longer utilizing CASA up there. So our CASA program is one of the only ones in this region now. We are continuing to have discussions about ways that we can better utilize them here in our county. So we are revitalizing the memorandum of understanding and updating it really because it hasn't been updated since the inception of CASA, really. And there's been a lot of changes. So that's something we're continuing to work on. Something that I think could be helpful if anybody here has suggestions. We've had discussions, and we're going to continue having discussions about how to recruit attorneys to represent parents in these cases. We don't have attorneys who are representing parents, and we're trying to figure out what the root cause of it is, what we can do to incentivize attorneys to come. So if anybody has heard why folks aren't able to take these cases, if it is the pay is not enough, if it's simply that their caseload is too high, if anybody has insight into that, please let me know so that we can try to strategize in our subcommittee about what we can do to help attorneys take more of these types of cases, because parents really benefit from having somebody next to them in the courtroom who could answer their questions and walk them through this process, because it is extremely confusing. Which is why we have a court navigator in criminal cases. The justice system is just incredibly confusing to people who haven't been through it. So we want to continue having that discussion. We want to continue trying to find ways to bring attorneys into this world. So if anybody has ideas, please let me know. Our next meeting is going to be on March 20th. We are predominantly going to be discussing the same things again. The one thing Judge Needham would like us to talk about, which we very briefly had an opportunity to talk about, is providing a survey to parents. What are their difficulties in navigating the system? Do they feel like their voices are being heard in the courtroom? So we are trying to come up with like ways to implement a survey like that, or if it is even feasible to implement a survey like that, and really how would we get it out to the parents? Is it going to be mailed out? I know some counties have like an iPad outside of the courtroom where they can answer those questions. So continuing that discussion and seeing how that could maybe work for St. Croix County.
All right, good. Any questions? No answers on the lawyer question? Okay. All right.
Amber's got something.
Oh,
Just a suggestion on that. Have you guys considered preparing maybe like a short like CLE that you could offer for free to local attorneys, on like procedures, or just sort of like a 50-minute 1-credit CLE that could be offered for free? I think the Bar Association could probably help maybe with that as well, but that might be a way to sort of get people's comfort level with what you're looking for, to an area where more people might be willing to take it. And I'm thinking too, like more younger attorneys in the area that are looking to build their caseload and their clientele. If you offered something like that, that might be a way to drive an interest and then also an awareness in the need.
Great idea. Perfect. Thank you very much. I will try to put together something like that.
and to your point, we've had an influx of at least one, I know of, young attorney who's taking on some of these cases to build his practice, and so that's a good target audience, and he's been a big help. So, all right. Let's see, Judge Waterman, the Criminal Justice Committee.
Well, some of our agenda items have included the court navigator, the OAR diversion. You've heard about those things. Another item on our agenda has been ways that we can try to improve appointment of counsel for the indigent. So anybody who's charged with a criminal offense has a constitutional right to a lawyer. If you can't afford a lawyer, one's appointed for you at public expense. The public defender is the first line of defense. For those who don't qualify for public defender, judges can appoint counsel at county expense, where the defendant repays at an amount that they can afford. And what we've seen over the past several months has been longer and longer time periods to get qualifying individuals matched up with lawyers. Sometimes it's as much as a month, 2 months, some cases 3 months. And we'd like to see if we can improve that. There are a number of different reasons why. We're looking at those, see what we can do to make improvements for efficiency. But the importance of it is that, a month delay, a 3-month delay is a significant delay, especially if you're the one charged with a crime. It prolongs your case in the criminal justice system. It delays justice for victims, and it unreasonably consumes court resources with unproductive hearings. So I'd like to see if we can shorten that time period, get lawyers up front, and get these cases moving faster.
All right. Any questions? I don't know, public defender, comments on that?
It's always going to be the ongoing struggle. It's something that I think where most of that focus is the people that are appointed that are eligible through our office. It's not the ones that are non-conflict that we and the in-house staff can take. It's the ones that have to go outside to private bar counsel to be appointed on for various reasons, and conflicts being the primary reason. Because there's been I think since last fall, we had a kind of policy change where we didn't, what's called farming a case out, send out any case that wasn't, that we could essentially take in-house. And so everything that we can possibly take, we are. It's just those clients that are just outside kind of our ability to take. And it is the continuous struggle of finding attorneys out in the field. And while attorneys retire, there's not this new crop of attorneys necessarily coming into the fold so much. And some of it is that, some of it is the ability for the attorneys that we've had in Pry Bar to be accommodated by various Zoom or things like that, because they're in 18 different counties, and it's just hard for them to kind of devote a substantial amount of practice time here in St. Croix when they have other obligations. And so there's this balancing act of trying to convince those to kind of be in here, while we also have needs in other counties as well. And so it is always going to be an ongoing struggle. I just wish that we had more attorneys, and sometimes it's the nature of the offense that causes some of these delays as well. And I will say, and it's something I've said over the years as well, and I continue to kind of say this, it's unfortunate, and I certainly wish we had a better solution. However, I just recently had a meeting with our my regional boss in Eau Claire County, and we often compare our size and numbers to Eau Claire County because we're similar populations. And not to say that this is any excuse or anything like that, but just to give some perspective, currently in Eau Claire County, they have a list of over 200 people that are able to be appointed in-house that they're waiting for appointments to get in to and that's excluding the Pry Bar. So they have a list substantially longer and wider than ours with much more attorneys to pull from, and they're still struggling with that. And so, yeah, I wish we had better turnarounds. I wish we could get everybody appointed within 30 days. It's just, that's the reality. And so we will continue to put efforts, and we continue to try all sorts of practices, whether it's emailing, whether it's calling, whether it's meeting people in person. It's me also sometimes taking Pry Bar in and mentoring them, and which I've done recently with a couple other attorneys that have come into the fold that I unfortunately can't seem to kick out of my office because they're in my office almost every day getting mentoring. But that's what I try to do to kind of help in these kind of situations, to kind of bring these attorneys in. And then, like I said, it's just hopefully we just get some more in. And every year I kind of pray on new grads coming out of law school that says that they want to kind of open up a shop in Pry Bar. But I also just look around and say, how many shops are opening up a Pry Bar in our county on new attorneys? I mean, I don't see those. I wish we had those. And sometimes it's also, I will say this too, we have tried on some of the local firms that have hired new attorneys in to say, look, one of the things that we talked about recently was trying to craft a letter to Pry Bar that says, okay, you've hired an associate. Here are the number of people that we are currently, have on an average month. And here are potential billable hours that can give you basically, 2 200 billable hours on a new associate that says, if you bring in a new associate, there are these hours available that you will have this income coming in. That's one thought that we had to kind of maybe give that perspective on the financial aspect to say, look, you bring in somebody, we can guarantee you almost these hours to kind of bill out. And maybe that's a different approach that we haven't necessarily tried on that. But other than that, I mean, we're always open to creative solutions or ideas to kind of suggest to how do we get those firms that aren't taking our cases to start taking public defender cases. And at least that was the latest idea that we just talked about last week of kind of having that letter kind of generate to those firms.
All right, good. A couple of comments on that. First of all, I think I mentioned before, I'm on the Chief Justice's Committee on Attorney Recruitment and Retention, and this is a statewide problem. In some of the far north counties, they don't have any attorneys to speak of that will appear in person in court. They rely on Zoom from Madison to get a lawyer. Bayfield County, Judge Anderson, our chief judge, is basically mostly Zoom, and you know, unless it's a significant evidentiary hearing or trial, that's how he operates. So that's a problem, and our committee really hasn't come up with any great answers. You know, there's talk about paying back student loans for law students and other things like that, but how you actually get somebody into St. Croix County and taking these cases, you know, I'm not exactly sure that's going to be the answer. We've got both deans of our Wisconsin law schools there, and they talk a good game, but you know, really, are these lawyers really going to come out of Madison and go to Sawyer County? St. Croix County, maybe. Some of these other counties, not so much. So that's one point. The other thing is, I think to the degree that we can, as judges and as part of the system, create efficient ways for attorneys to use their time, we create opportunity for people to take more cases and to do their jobs better. For example, I know just our block scheduling, I'm going to leave here and go do that. Judge Waterman did it last week. I've got 90 cases scheduled for 2.5 hours. In the old days, we would have 15 minutes apiece, though perhaps there's multiple cases, so let's call it 70 cases. That would have been 2 days of court time just to have the status conferences, and we'll do it in a couple of hours. And that translates into extra time for the district attorneys, the public defenders, and everybody else, even though it's kind of irritating to sit and watch us do our work for 2 hours. But so as we can think of things like that to do, to create efficiencies in the system, I think that'll help. And I think, Sheriff, you even had an idea recently, I think, with regard to jail access that you're working on. Okay, so that could make it easier for attorneys to get access to folks that are in custody, and that could speed up the system too. So good job there. And let's see, domestic violence. Judge Black isn't here, but Phil is.
Sure. So our next meeting is Wednesday, April 30th at 11:30, and that'll either be Judge Black's last or second to last domestic violence subcommittee meeting. So come out to that if you'd like.
There's a party scheduled sometime in July. July 25th, big retirement party for Judge Black. Everybody should come. I don't know when it is yet, though, but sometime that day. Perhaps it's all day. We don't know. So let's see. And executive committee, I don't know. Do they meet?
We don't meet, but if there are any items you'd like to see, and we can meet as needed, of course, but if there are any future agenda items, and I know we'll ask for that here in a second, feel free to reach out to Judge Needham or myself.
All right. Any other announcements or requests for future agenda items? We're always looking for a good idea for a presentation, so. All right, well, you let Judge Needham know if you think of something. And our next meeting will be May 8th, just a few days before we move into our new courtrooms. So it'll be very exciting. So with that, I think we're adjourned.